So a recent decision striking down a state's Second Amendment Preservation Act is now being used in the dispute between the state of Texas and the Biden administration over the border. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank the sponsor of this channel, which is First Form, and make you guys aware of a really cool giveaway that they're doing in partnership with Vortex. If you go to the First Form website down below, that's linked in the details section in the pinned comment, or just go to the link here on the screen, you can enter into the giveaway, and Vortex is going to be giving away about $25,000 in products and prizes, and then also 3 grand prize winners will be brought out to the Vortex headquarters, and then also you will get to train with the Vortex Pro staff. And on top of all of that, if you use my dedicated link down below and your order is actually over $50, you will get an automatic free 4-pack of energy drinks. So thank you to First Form for sponsoring the channel. Check out those links down below, enter to win that giveaway, and then also get your free energy drinks. Now, as I mentioned in the intro, in this video, we need to talk about some new decisions from the Supreme Court and then also some circuit courts that are now being used to support Texas in their dispute over the border, but also some decisions that are being used by the Biden administration essentially to argue that SB 4, this Texas border law, should be in fact struck down and should not be allowed to be enforced by the state of Texas. The state of Texas is using the Supreme Court's recent Second Amendment decision to support their right of self-defense and to essentially defend their border. Texas argues that the Rahimi decision shows that a facial challenge brought by the United States government against the state of Texas and also Texas SB 4 is in fact invalid. And essentially Rahimi and the rationale used by the Supreme Court should lead to this case being thrown out and that the lawsuit brought by the United States government should be invalid. But the federal government argues that Rahimi should not change the outcome of this case at all. But now also the federal government has submitted their recent win out of the 8th Circuit Court of Appeals, which struck down a state of Missouri's Second Amendment Preservation Act, that is their sanctuary law, the SAPA law. And the Biden administration now argues that SB 4 should be struck down by the 5th Circuit, just like the 8th Circuit struck down Missouri's SAPA law. So this is some very interesting developments in this case. You have the Missouri SAPA law, the recent loss in that case being submitted in the 5th Circuit to essentially strike down the Texas border law. Now, we need to do some background on this case so you understand what is going on and how Rahimi and this Missouri case are actually impacting this lawsuit. So Texas SB 4 effectively makes it a crime for an individual to violate federal law by crossing into Texas at any location other than a lawful point of entry. Essentially, SB 4 in some ways is simply a state level enhancement or a mirror of federal law, and so that's what Texas put in place so they could defend their own borders. SB 4 also has a mechanism where judges can issue orders essentially sending those individuals back where they came from. This bill was challenged by the Biden administration, and a district court on review issued a preliminary injunction preventing Texas from enforcing all of SB 4. The lower court in this case placed a universal preliminary injunction on SB 4, and it broadly blocks all enforcement of the statute. The lower court found that SB 4 was facially invalid. So Texas then appealed that injunction up to the 5th Circuit Court of Appeals, and in response, the 5th Circuit issued an administrative stay on that lower court universal order. When this case reached the 5th Circuit Court of Appeals, various cases were then consolidated, and then at that time, most of these plaintiffs then filed for emergency Supreme Court review. They wanted the Supreme Court to intervene on an emergency basis. What they wanted was that administrative stay to be removed so that they could still block SB 4. Well, we then received an order from the Supreme Court denying the Biden administration's request to vacate the administrative stay. So essentially the Supreme Court sided with Texas. Now, interesting, what happened after that is that very same day when this case was sent back down to the 5th Circuit, the 5th Circuit real panel who was going to review this case and who has reviewed this case decided to remove the administrative stay on their own. Then soon after that, the 5th Circuit heard oral arguments on whether or not they were going to grant the preliminary injunction in favor of the Biden administration, which would again more permanently close the door on SB 4's implementation. Now, during those arguments, there were some concerns about the United States government and whether or not they can seek this type of universal equitable relief against Texas and SB 4. There was a lot of dispute during those hearings, especially from one of the dissenting judges, Judge Oldham, who had concerns about this lawsuit and whether or not the federal government could bring this type of lawsuit, and then also the universal form of relief that the federal government was seeking against the state of Texas. Now, after those arguments, the state of Texas submitted a supplemental letter to the 5th Circuit. They submitted the United States versus Rahimi case as authority to show how the facial challenge brought by the Biden administration has in fact failed and that the Fifth Circuit should uphold SB4. They're using Rahimi as support to show that this facial challenge to SB4 brought by the Biden administration is not valid, similar to how they said that the challenge brought by Mr. Rahimi against the domestic violence restraining order law, how that was not a proper facial challenge. The letter submitted by Texas to the Fifth Circuit states that this court should not repeat the district court's error on appeal. Plaintiffs have failed to show that federal law preempts SB4 at all, let alone in every application. As Texas has explained, SB4 mirrors and supplements federal statutes. It does not conflict with them. Regardless, because the Constitution trumps statutory law, SB4 can be applied pursuant to Texas' self-defense authority, which at a minimum covers armed incursions by violent transnational cartels and does not require the consent of Congress. Because SB4 can constitutionally be applied in at least some of its applications, Rahimi dooms plaintiffs' facial challenges. So Texas is using the Second Amendment case Rahimi to support their SB4 law. But in response to this, the Biden administration has submitted their own Second Amendment case, a case they recently won in the 8th Circuit, as support for why SB4 should be struck down by the 5th Circuit. The federal government claims that the 5th Circuit should follow what the 8th Circuit recently decided when they struck down Missouri's SAPA law. Now, if you're not aware of what happened in Missouri with the SAPA law, quick rundown. Essentially, Missouri passed a Second Amendment Preservation Act, the SAPA law, and it essentially set the state's standards for what they believed the Second Amendment was, and then it placed restrictions on local law enforcement and local authorities from being able to enforce inconsistent laws, inconsistent federal laws, which in fact violate the Second Amendment. They also used the 10th Amendment to remove a lot of funding and support for federal agencies who would want to enforce federal laws, which they believed violated the Second Amendment. So essentially, it was the state of Missouri setting their pro-2A policies and not aiding federal agencies and federal authorities and agents in their actions, which would violate the Second Amendment. Now, also interesting with the SAPA law there in Missouri is the fact that they didn't really give any authority to the state agencies or the state authorities or the attorney general or anybody like that tied to the state. They didn't give any authority to those individuals to file lawsuits. Instead, all the power was given to the private citizens to file lawsuits against any state agent who violates that SAPA law. Now, that was challenged and brought up to the 8th Circuit, and the 8th Circuit on review ultimately sided with the Biden administration striking down Missouri's SAPA law. So that's generally what the Missouri SAPA law did, and that's generally what happened. There was a lot more nuance in that. But the letter the Biden administration just submitted to the 5th Circuit essentially argues that that recent decision out of the 8th Circuit dealing with Missouri SAPA law should mean that the SB4 law in Texas should also be struck down. They state in their letter that in the Missouri case, the United States sued the state of Missouri and its governor and attorney general, alleging that a Missouri law violated the Supremacy Clause. The state argued that the United States cannot sue to enforce the Supremacy Clause because it lacks a cause of action. The 8th Circuit squarely rejected that argument, holding that the United States may sue in equity to enjoin preempted state laws. The court recognized an equitable tradition of suits to enjoin unconstitutional actions by state actors. It noted that based on the equitable tradition, the United States has sued in other cases to enjoin a state's law's implementation and enforcement or for other appropriate relief. And it held that the United States could proceed under the same tradition to enjoin enforcement of Missouri's enactment. In this case, the United States proceeds under the same equitable right of action as it did in Missouri. This court should reach the same conclusion as the 8th Circuit and should reject Texas's argument that the United States lacks a right of action. So this is a very important development in the state of Texas lawsuit over the border issue. There's a lot of arguments going on right now. In this case, you have various Supreme Court precedent being submitted to the 5th Circuit, like the Second Amendment Rahimi case. Texas is trying to use that to protect their border law. And now you have the federal government, the Biden administration, using their recent win in the Missouri SAPA case as support for why the 5th Circuit should also rule in their favor, just like the 8th Circuit did, and strike down SB4. So things are getting really interesting. There's a lot of two-way cases that are being submitted and used as additional precedent and support in this border dispute, which is very interesting, where you have a border issue being supported by a ton of 2A cases. And again, as things develop, if anything else changes, I will let you guys know. Also, if you like this video and you like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.